Thank you. And then you're here with an attorney, Ms. Ferguson, if you'd announce.
Kelly Ferguson, attorney for Robert Cosper.
Thank you. And now, Ms. Nicole Cosper, I have you as a custodial parent. If you would announce your name, your full name.
Nicole Cosper.
Thank you. And state if you would announce without giving me an opening yet. I've got some admonitions to make first.
Yes, Your Honor. So it's the Assistant Attorney General Maz Asif for the state of Texas.
Okay. Now let me swear in the parties, the Cospers, if you would both raise your right hands. I need to swear you in. Your both hands are raised. Do each of you swear to tell the truth, the whole truth, and nothing but the truth? Starting with Mr. Cosper.
I do, Your Honor.
Thank you. And Ms. Cosper.
I do, Your Honor.
Thank you. If you lower your hands now, I'm going to tell you a couple things about my court before we actually get started. One is that I'm an associate judge. I've been appointed to hear cases filed by the Office of the Attorney General, their child support unit. As associate courts, we are courts of record. However, they do not give us or they do not assign court reporters to our court. We have, can you see it? A digital recorder. That's the official record. So I make you aware of that. So your answers obviously need to be verbal, loud enough for the recorder to pick up and the court to hear. No shaking your head or nodding when answering questions. That won't record. And no ahas or ahs. You are in a formal courtroom, so I expect yeses and nos. The other part of being an associate court is that for you to be aware that you have the right of appeal to the higher district court level, the elected district judge for this court. And so if at the end of the hearing you need more information on that, I'd be happy to give it or have the state attach a document to the end of your order. But you have the right of appeal if you believe the court made some error or you didn't like what happened or you want to start over. You do have the right of appeal, just so you're aware of that. The second part of the recording issues that I'm more concerned about right now to tell you about is that you heard me announce we were live streaming on YouTube. It is a requirement under our Constitution that the courts are open to the public. That happened forever while we were in courtrooms and people would come in to observe proceedings or be part of the cases. However, when COVID happened, they set up the Zoom courts as a way to keep conducting business while we were getting through COVID. And they set up live stream on YouTube as a way for the public to log into the app and see whatever courts were working on Zoom, since they couldn't go to the courtrooms when we weren't sitting on our benches. A lot of people went back before COVID ended. Everybody went back after COVID ended to the courtrooms so people could walk in, observe proceedings again the old-fashioned way. However, since then, the child support courts were allowed to continue on Zoom. It was working for our program. People liked it. We got a lot more participation that way, and you could be here from home or work or what have you. It just worked better for our program, so they let us continue. But I'm still under the open courts requirement. They're still making us live stream on YouTube. I'd say that as a long-winded way of telling you, be careful. You're on the internet. Don't blurt out your home address, your social security number, your cell number, something you really would not want out there identifying you. Because if you say it, I could not take it back. I don't want anything out there that could be used or abused. And so I make you aware of that. Now, if I think you're coming to a point where you might say something like that, I try to stop you. But if it's out there, if you say it, I can't stop you. I cannot take it back. So it's a big deal to me that you all are aware of that. The last part of the recording issues is do not record. It would be considered in violation of our laws, subject to contempt of court, punishable by a fine and or a jail sentence. So do not record anybody here in the virtual courtroom or anybody outside observing in. So let me start with you, Ms. Ferguson. On behalf of Mr. Cosper, do you have any questions or concerns about any of the recording issues?
No, Your Honor.
And you consent to go forward on Zoom today?
Yes.
Okay. And Ms. Cosper, on your own behalf, do you have any questions about the recordings at all?
No, Your Honor.
And you want to go forward on Zoom today? You do consent?
Yes, Your Honor.
Okay. Thank you, folks. So then let me defer to Mr. Asif to go ahead and he already announced himself, but give me an opening statement followed by Ms. Ferguson's, and then we'll go to testimony.
Yes, Your Honor. So we're here today on a contested reset issue. It's my understanding that Ms. Ferguson has filed a motion for continuance in this matter. Ms. Cosper is opposed to the continuance, and I have no position.
Okay. So y'all didn't get, is this the first setting or are you aware, Mr. Asif?
Yes, Your Honor, this is the first setting.
And nobody's asked for continuance, obviously, if you weren't able to be in court before now. Mr. Asif, you haven't seen anything prior to now as for continuance?
No, Your Honor.
Okay. Then let Ms. Ferguson go next and just your request for and why, Ms.
Yes,
Ferguson.
Your I was recently retained just a couple days ago by Mr. Cosper. He's been trying to find counsel who had availability for today. And so we were able to get everything sorted so I could be retained and I had availability. And Your Honor, yesterday, along with my motion for continuance, I did file a petition for dissolution of marriage in Hayes County District Court. I received that back today at 11:46 a.m.
Dad's counsel joined days ago and filed divorce in district court, seeking consolidation that centralizes custody, support, and property issues. Mom wants progress today. Dad wants preparation time. Classic tension, speed versus due process. Which would you choose for a fair outcome?
With the cause number. So because of timing, I haven't been able to file the motion to consolidate these matters. We would ask that this be continued just so to allow for the housekeeping matters so we can pull all of this together in one court, if approved, and consolidated to the district court with regards to the divorce proceedings.
So just so recent that Ms. Cosper is not on official legal notice yet?
Correct. We have, I literally also got the citation back maybe like half an hour ago. So we haven't been able to serve her or ask if she would want to just sign a waiver and accept service. So that's just where we're at with timing based on my hiring and getting everything done and this being our first hearing.
Okay, go ahead and give me the cause number if you have it. Can you
Yes, ma'am.
retrieve it and give it
is.
to me?
Yep, it is 25-1430-DCE.
Okay, might not have gotten that right. 25-1420? 30. And then I didn't hear the letters at all. Can you spell them out for me or give me a...
Of course, D as in Delta, C as in Charlie, E as in Echo.
There you go, DCE, got it.
Yes, ma'am.
Well, from their names, I assume there was a divorce, but usually, and Ms. Ferguson, I'll have you address this maybe now, maybe later. If my job is to hear cases and I assume you filed an objection, and if it's a divorce, you don't even have to file an objection. The final case should be in district court. And since you're just starting a divorce, and I don't know how long it takes to do discovery and do all that stuff for the divorce part, is there any reason I'm going to hear from Ms. Cosper next, and I haven't done it yet, but if I were to reset this, couldn't we do at least a temporary order, some kind of Band-Aid approach so that these parties don't go without any orders for a long period of time till they get to the divorce court? Or
Your Honor, I believe that we could probably we did request temporary orders in the divorce proceedings. So as soon as we have service or if Ms. Cosper will agree, with a waiver, I can get some hearing dates for temporary orders, usually within like 30 days, at most 60, depending on everybody's schedule. But I mean, I always make my divorce cases with children priorities. So I would ask that we have that time so we can be prepared. And if we want to serve a little bit of preliminary discovery, we are better suited. The parties have been working under a basic agreement, but it's based on what Ms. Cosper wants, not what my client would like. So at least they are sharing some time with the children and he is providing some support. But I do think it's unfair to go forward when I have recently been retained and we should have the opportunity to be able to prepare and have a full hearing. And if I do want to issue any discovery, we are allowed to do that so we can be prepared for that hearing.
and it's not late in the day yet, it's after lunch, but is there any way you'd be able to actually obtain a setting for a temporary orders hearing if I didn't hear it myself because I have a calendar for the rest of the year, but I'd like to try to move some cases and help my district judges keep some matters off the table. Maybe you don't have to get a, immediate hearing if I hear some of it, but can you get it?
They won't give me a hearing until we have service or until there's a waiver on file. So I have the citation. I had planned to get everything to the constable in the next tomorrow, ideally. I know my client is also helpful to run that over to the constable's office. I just need to email it to him. So assuming there's no waiver and acceptance that way, we should have her served next week. And then I will obviously include her in any correspondence to the court and reach out to find a date that is agreeable.
Even though that they're backlogged or you can't get anything for a number of months.
I had a final hearing and I think I only had to request a 2-hour final hearing like 5 weeks out. So Judge Hayes has been pretty diligent on moving his docket. And if for some reason he is backlogged, I do obviously have the district judge that I can reach out to get dates.
And since you just started, you don't even know what the contested issues might be if I were to have a hearing today, or?
Probably everything. We did supply through Mr. Azif a offer that was rejected. The counteroffer was obviously completely opposite, nowhere close to what were my client's position. So we did make an attempt today with the time that we have had, and they're on total opposite ends. So,
But could you tell me if they're more of the parenting issues or the financial issues or just everything?
all of it, Judge. Like we would need to tackle even conservatorship. So,
If you were to have a proper temporary orders hearing, would you have witnesses? Or is it just the he said, she said from the actual parents?
I haven't been able to discuss that further with my client, but I do know will be probably issuing some very basic discovery that I do need, such as like income from mom and work schedule, things like that. So,
And then I guess maybe my last question is, my God, don't tell me I forgot. No, it had to do with, no, it was important to me. Hold on a minute. This doesn't happen very often. That's got too many facts in my brain today. The divorce, the time getting a hearing there, the witness issue, the contested issues.
Two kids, ages 13 and 11. Separation about a year. First setting today. Judge weighs whether temporary orders land now or move with a new divorce. Best interests drive decisions. With school routines involved, is immediate stability preferable to a fuller, later hearing?
Contested issues. Oh, yeah, simple. Kids, how old are the kids? How many and how old? Because I do care about how, what's going on, how they're doing it. And if it's a real contest on visitation or it's not happening, I'd like to know that before I rule and send this away or keep it.
yes, Your Honor, there are 2 children. Their son was born actually today. Today's his birthday, May 15th of 2012. So he turned 13 today.
Okay.
And then their daughter is born August 16th of 2013. So she is 11, will be 12 in a few months.
And the follow-up question, do you know how long they've been separated and maybe waiting to get heard in this court?
They've been separated since the end of March of last year.
So it's been slightly over a year.
Yes, Your Honor.
Okay, I have that the state filed this in November, although I know they don't, even if mom applied or anybody applied earlier, that they have so many cases they can't file overnight. And from November, service dates were in November and December. And this being, you wouldn't dispute that this is the first setting?
This is the first setting.
First setting, okay, thank you. Okay, did you want to call your client as a witness and not necessarily if you've given me all your legal arguments already, or did you have any factual arguments to give me through your client?
I believe I've stated his position.
Okay, then Ms. Jasif, I'm going to ask you to call Ms. Cooper and elicit her testimony on why she's opposed to the continuance.
Yes, Your Honor. I'll call Ms. Cooper. Good morning, Ms. Cosper. Beg your pardon. Good morning, Ms. Cosper. Can you please state your name?
Nicole Cosper.
You said the name of your child?
I'm sorry, what was that?
Could you please state the name of the children?
Gavin James Cosper and Mila Rose Cosper.
It's my understanding today you're opposed to Ms. Ferguson's request for continuance. Is that correct?
That is correct.
Could you please explain to the court why?
I'm opposed Primarily because I filed with the Attorney General's office in August of 2024. Mr. Cosper was served on November 29th, I believe, of 2024. This case has been pending for many weeks now, and I feel like there has been plenty of notice and time to hire attorneys or to do his own discovery. I prepared with 37 exhibits today in order to present to the Attorney General's office and the judge for what I'm asking and why I'm asking for what I'm asking for.
Is there anything else you'd like the court to know?
About the specific situation?
Yes, ma'am.
Yes. I would like the court to know that I am a victim of domestic violence.
Ma'am, if we could maybe narrow our just the continuance issue, ma'am.
The continuance issue, I would say that we've had plenty of time to gather our facts from the time that we were both served in November to this date. Since we've both been on notice, we have been able to gather facts and be prepared for today prior to this motion of continuance that occurred yesterday afternoon.
Thank you, Ms. Cosper. I have no further questions, Your Honor. I'll pass the witness.
Okay, I guess
37 exhibits via screen share and credibility disputes. In associate court, uncertain facts invite appeals, meaning a full replay in district court. Forcing a rushed hearing with new counsel almost guarantees duplication. Would you prioritize speed, knowing a second round looms?
this is for everybody, but Miss Ferguson already knows a lot of stuff. If she's done family law and knows how the system works. Ms. Cosper, inadvertently, you may have given me a reason to reset the thing because, well, one, it looks like nobody has witnesses, but you might have documents. 37 documents on screen share on a computer is going to take, I don't know how long, if you actually want me to consider any of them or admit any of them and, one at a time. In person, it's usually a lot easier, a lot quicker, and people have duplicate copies to share, and you probably don't have that here today, and we'd have to see them for the first time on the screen. Just so you're aware. So that's one reason that it might be longer. Two is witnesses. Once you get into contested stuff, and I'm the queen of he said, she said. I've been doing this for so long. That's pretty much all I hear. I do have the benefit of lawyers, or the luxury of having lawyers do that for me, and elicit testimony, elicit evidence, and bring witnesses to corroborate stories that might help you in getting what you want. But I have the strictly he said, she said. How can I say this? I'm not going to accuse anybody of lying, but everybody puts things through their lenses, and some of it I believe both people, and sometimes I think both people are lying, and it's all in the same case with the same facts, supposedly. And so I never really know if I got it right or not. I do my best, and guess what? This is the thing you need to know, is that because I'm an associate judge, I told you earlier about people's right of appeal to a higher level from this court, that Ms. Ferguson, if she's not prepared and I push it forward and it doesn't go her or client's way, there'll be an automatic appeal to the district court level. And guess what? You get to do it all over again. And you would have spent my time and your time doing it here once, only to have to do it again. I will not ask Ms. Ferguson to waive her right of appeal. That is a right. Then I used to make people, it's like, you want my time, you have to waive your right so that this doesn't happen twice, but I don't do that anymore. You'd have the same right if you didn't like what happened to appeal me if it didn't go your way. And so I don't make people waive their rights to appeal anymore. So it's not over with here. If I do something today and I push Ms. Ferguson and she really feels like she's not prepared and she can't respond to whatever you're going to say, on top of however long it's going to take with 37 exhibits, not even considering what Ms. Ferguson has or how long it's going to take just for testimony besides documents. And because there's a divorce, I have zero jurisdiction in divorce matters. So sometimes it's better that you are in front of a judge that hears the temporary orders. That's also going to hear the final divorce. So you don't have different judges hearing different things at different times. And and people not admitting that they said or didn't say something in the prior court, and you didn't get a copy of the record and didn't have blah, 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 blah. There's so many reasons why maybe it should be in one court, especially on a divorce, because you still have to get a divorce. I can't hear any part of the divorce, just the children part of the suit. So given all that, and knowing and me putting Miss Ferguson's feet to the fire, if she gets you served right away or you sign a waiver and you can get your temporary orders here quicker rather than not, why do you think I should hear it today after all? Any other reasons or any other something that would persuade me that there's some kind of emergency or thing that needs to happen I can put a Band-Aid on this and then ship you out on a short hearing, or what else could you say?
I would say that if we are going, if it's in your judgment, if it's in your best judgment to push this back further, that I would like some temporary orders on child support and custody of the children until the divorce is finalized.
I have no objection to that request.
You know, Ms. Ferguson, sometimes I do this quickie interim order so that people aren't snatching children from each other, and people have certain rights and certain obligations but not be held to them, even if it's high or low for child support or minimal or not for visits. Is there any way to do a finding of possession and finding that he should be exercising a certain visitation that he's already had, and a finding of some support on an interim basis to get you into another court quicker?
That's going to cause even more time and money for my client, because then if you order something that we don't agree to, obviously I can appeal that, or I'm going to have to file a modification for those temporary orders possibly, which is going to clog things up even further.
I've been doing this
Why
a
would
long
you need to
time.
modify temp orders?
Thank you, Mr. Asif.
Well,
Ms. Ferguson, you don't modify temporary orders.
Sorry, if I appeal the temporary order, I mean in
Start
that
all over.
sense, start over that's what I mean on the modification. I apologize. And these parties have been, somewhat co-parenting in the last year, but we're not agreeable to continue and in an order what they are doing. And 37 exhibits, there's no, I should have the opportunity to be prepared for this hearing, and 37 exhibits, and then the possible allegations that she briefly stated. We need time to look into that and be able to properly defend my client if there's those other allegations in there. So again, I would object. I'm asking for this continuance. I'm ready to file. I can probably have the consolidation even on file for tomorrow, or filed by tomorrow. We're working as quickly as we can. Just because Ms. Cosper approached and filed with the AG in August, my client even signed, I believe, a waiver of service, or at least that's the document that I have seen. So it's not like that we are purposely delaying. He has been providing some support. I know will continue to do that because he cares about his children, but we won't agree to anything. And I feel like I need the time to review all the documents and be able to put my client's position and defend against Ms. Cosper's position in a relatively reasonable manner. And trial by fire today with that many exhibits just seems unreasonable.
Well, I do it all the time, but not really. Just the he said, she said, not 37 exhibits. I was thinking of something else, and darn it, I guess I missed lunch and I need lunch now. What was I thinking? Oh, yeah. Interim order. Is this a custody dispute at all? Or can you at least admit or agree or concede that mom has current possession of the child without conservatorship orders?
Children in the home that the parties were residing in, which she owns, as I think it will be separate property. So, and they're on a schedule and they're on a routine. But again, my client's position is very different of what he would like moving forward. And I think
Well, I'm not calling it conservatorship, but is there any dispute about who has primary possession of these children? Or
well,
even possession?
she currently does because she has established that by her own accord, not by agreement. So,
Well,
I
I'm trying
mean,
to prevent, if I send it up, I'm trying to prevent the snatching thing.
I think from my clients, we could maybe agree on a temporary basis on one issue, but I don't like, we asked that everybody stay in their current school districts for geography, and even Ms. Cosford would not agree to that. So,
Well, it's the end of the school year. You don't think you can get to a court before school starts in the fall and sort that out there?
yes, I would hope so. I'm hoping we'll be in court in June.
Well, yeah, but I'm trying to put something that just at least puts that stamp of, so people don't get the idea that possession is 9/10 of the law and keeps the children and then has that advantage before mom can get into court if the children have been residing with her during the separation period. And so it sounded like you might agree with it, but then I'm not sure you just did with the school district issue.
No, we made an offer and she did not agree to any part of our offer. So we are disputing geographic location, conservatorship, possession, child support, arrearages. I think probably, let's see what else.
Conservatorship,
Like,
whether it's joint or whether it's primary.
We want a joint with no primary. And
Primary.
I believe, correct me if I'm wrong, I think she asked for sole managing. So,
Okay, well, maybe if I do something you don't like it, you can appeal that. But anything else, Ms. Ferguson? Well, let me finish, Ms. Ferguson. Anything else, ma'am?
asking for that continuance so we can consolidate this, hear it all at once, also deal with any other issues with regards to the divorce at the same time, because those can affect the children. And I feel like doing it piecemeal is unjust and unfair, not only to the parties, but also to the children.
Okay, and Mr. LC, if you want to say something, what is it, sir?
Yes, Your Honor, I have a list of reset dates if necessary.
Okay. And Ms. Cosper, did you have anything else you wanted to say?
I stand by that. I think it's been a long time now, and having some temporary orders until the divorce is finalized, and continuance of what we've been doing in regards to possession, and then establishing set child support for the children would be beneficial for the children. So that way they can continue on the way that they have been, and we can both be legally binded to that agreement. And the children can continue to see their father the same way that they've been seeing them over the past year. And we can establish a set number for child support. And that will actually take something off the plate in the divorce process, I believe, because unless they want to appeal. But I think it's in the best interest of Gavin and Mila in order to get something legally on paper from now moving forward.
Well, if you think it's been a long time since the filing in November, even the application in August, then, or whenever that was, you haven't been around court for much time. You're not going to get a divorce overnight. You're not going to get orders overnight. It just doesn't happen that way. It's already been 5 months to get here. I've got lots of cases. I hear tons of stuff. The AG has thousands of cases they process. And so it just doesn't happen the way people want it to happen, which is on their time. It works on our time. So now there's a question of the divorce. You haven't even been served with it. Are you willing to sign a waiver on that, or you want official service with the pleadings by a sheriff or constable?
I would only be willing to sign a waiver if we could establish temporary orders today.
Well, that ain't gonna happen. Okay. I'm not gonna make you sign waivers and they be conditional or whatever.
Okay.
This is what I'm gonna do. This case is not ripe or ready or for this court because of the issues I've already heard.
Your Honor, I'd have to object to a referral. I think the onus is on Ms. Ferguson to get a setting, and I'd like to keep this on our docket in case that doesn't happen.
I'm not gonna do that, Mr. Asif. I'm gonna refer the case out
Sure.
and I will make certain orders in the order, and Ms. Ferguson can appeal me if she doesn't like it. And if you don't like it, you can appeal me and make
Continuance granted. Interim finding that mom currently has possession, dad's access by agreement, and referral for temporary orders in district court after service or waiver. Cases consolidated under the divorce cause number. No final support today. Is a status quo interim fair here?
a court make me take it, but that usually doesn't happen either, sir. This is what I'm gonna do. Interim order. Referral to district court to be set for temporary orders as soon as practicable after service or appearance or waiver on the mother, the custodial parent. In the meantime, I'm going to make a finding. I've heard enough, including especially from your lawyer, Mr. Cosper, that mom has that the children have been residing with mom. So I'm going to make a finding that the custodial parent has possession of the children. And that any access by the non-custodial parent shall be by agreement until further orders of a court. That Ms. Cosper was recently retained.
I think you meant Miss Ferguson
sorry,
was
Miss
recently
Ferguson.
retained. That's okay. I'm sorry to correct you, but just so
No,
your
I
notes
looked
are
up and I
correct.
saw Cosper and I'm thinking of his side, but they're both Cospers. I'm sorry. Yeah, yes. That Miss Ferguson was recently retained and her request for continuance for full temporary orders is granted over the mother's objections or the custodial parents' objections, and you can put their names. I'm just using that as shorthand rendition right now. That this court finds that due to the contested issues and exhibits and possible witnesses, that this case is not appropriate for the 4D court. The other thing I kind of wanted to say, because there's not a divorce yet, so I'm only referring to the AG case, and I don't want it to fall through the cracks. And I assume if you just got hired, Ms. Ferguson, you're not intending to let that happen, but sometimes things get to the bottom of the stack if it's in anybody's interest to delay, and I don't want that to happen. But I want a finding in there also that father's attorney, did I already say that? Well, I talked about service and appearance and I meant on the divorce, but I didn't say that there's a divorce pending. So somewhere that that father's attorney has I just guess asserted that a divorce will be filed. Oh, it already has been filed. I'm sorry. I did have a cause number. I'm trying to think right. No, so I don't need to say that. The divorce is already on file and a finding that it's under cause number blah blah blah. And that consolidation and service on custodial parent still needs to occur. Make that at the top somewhere with the referral. But yeah, and I just want to clear that. Due to the lengthy nature of this case, I'm not going to hear it.
Okay. Your Honor, could we not consolidate this matter now?
I don't have a problem with it. If you want to draft it, Ms. Ferguson, would you have a problem with it? You're muted for some reason.
Sorry, I have no problem with that. So go
Ms.
ahead and
Cosper, we could do one thing quicker, but you haven't even been served, and so I won't even ask you to sign it. But would you have a problem if I put the two cases together because there already exist? Our AG case with that cause number and the divorce case that is on file already. To me, it's an administrative thing that needs to happen anyway, because there's no way two courts are going to hear two different things on the same party. So we have to put the cases together. Would you have any objection for me to at least do that today and get that paperwork out of the way, even if you haven't been served?
Um,
It's going to happen anyway down the road, and it could just take longer and cost more because Ms. Ferguson will do the paperwork instead of the AG doing the paperwork for free, and me signing it for free. Well, all judges would sign it, any judges would sign it, but it needs to happen legally before a court will hear both cases.
I understand, Your Honor. I would not be opposed to combining the cases.
Okay. Then I'm not going to ask you to sign it because I don't know if that would constitute making an appearance without service or signing a waiver. So I just want you to be aware of that. And frankly, Ms. Ferguson, well, I do want you to sign it since you filed the divorce. So a separate order of consolidation of these two cases, and I assume you want the surviving order, the divorce cause number to be the surviving number.
I think that makes the most sense, Your Honor.
Consolidation into divorce with proceeding under the divorce cause number. Okay, so I want two orders, an interim order and a consolidation order. And I think I covered everything I wanted. And I get your point, Mr. Asif, but I don't think this is going to fall through the cracks. There's a lawyer on board, and Ms. Cosper. I want to say Cooper too, because that S looks like a no with my reading glasses. If you're not getting any feedback from Ms. Ferguson, you can ask the AG to place the temporary orders hearing and have it set before she does. However, I hope she does her job and gets it out quick so you can have a hearing in the next 30 days or so, or 4 or 5 weeks at least, so you can get down to business. I didn't hear any emergency that made me think I absolutely needed here today, that y'all have actually been co-parenting and working fairly well, and he hasn't kept the children from you and you haven't kept them from him. This was just a total Band-Aid approach so the court knows I did something and sent it away because now I can't hear the temporary orders hearing due to the lengthy nature. I had a bunch of cases and I probably still have more hearings left today. So it's not right for this court. Did I leave anything out, Ms. Ferguson, that you think might be necessary?
No, I think that takes care of everything, and this will make it go faster that I don't have to file the consolidation and set that. So I appreciate that.
Any chance you need to appeal any of that? I guess I won't make you tell me, but
I would hope not, but I would need to discuss with my client, and I would need to review everything, obviously.
okay, because if I thought you were going to appeal something that was objectionable, I try to fix it to make it unappealable. But I don't think I've said anything other than finding a possession that you could have possibly want to appeal. But
right. And
okay,
I think
I'll let you
we
figure
can
that out.
still deal with the possession order and the conservatorship when we have temporary orders, hopefully in a few
Correct.
weeks.
And Mr. Asif, I tried to talk slow because I was writing it all down so I don't have to remember it, but I hope you were doing the same. You'll have everything in there.
Yes, Your Honor. Just to clarify, so you'd like me to draft a referral order setting this matter for temporary orders as soon as practicable after service and appearance or waiver on Ms. Cosper for divorce under the divorce cause number. You're requesting a finding that Mrs. Cosper has possession of the children, that any access by Mr. Cosper will be by agreement until further orders of the court, that Ms. Ferguson was recently retained, and that her request for continuance for full temporary orders is granted. Over Ms. Cosper's objections, the court finds, due to contested issues and exhibits and possible witnesses, that this case is not appropriate for the 4D court due to the lengthy nature of the hearing. And I believe you're also asking me to write a consolidation order, consolidating the AG cause with the divorce cause under the divorce cause number. Is that all correct?
I think so, but the title of the first order needs to be interim order and order of
Interim
referral,
order and order.
not just referral. It does contain some content. I'm not going to say it. And also on the request for motion for continuance, that's too long, but those two things, interim order and order of referral. And then the second one is consolidation order of consolidation. Okay, I think I got it. Ms. Cosper, on the state's case, is there anything else without having a contested hearing today that you think I should consider adding to my interim order or order of referral?
What about,
No final custody or support. The court entered an interim possession finding, granted continuance over objection, referred for temporary orders post-service, and consolidated the AG matter with a divorce under one file. Takeaway: avoid duplication and appeals. If this shocked you, comment and subscribe.
support for the children, financial support for the children?
If I'm not hearing it to determine custody and visits, I'm not hearing it for child support. It all has to be heard at once.
Yes, ma'am. Yes, Your Honor. I don't have anything that I'd like to disagree with. I appreciate your interim orders as they stand, and I look forward to getting this taken care of.
I usually jump in if y'all let me just to do something, but I'm not today because I think your 37 exhibits and Ms. Ferguson's right of appeal just overrule all that. I'll be wasting my time and your time and her time and her client's money, really, because you need to do this twice instead of once. Okay, Mr. Asif, anything else, sir?
No, Your Honor.
Then the state's gonna draft the two orders, route them around to everybody. So Ms. Ferguson, be on the lookout, Ms. Cosper as well. So the sooner you sign it, the sooner I get them back so I can sign them and we can have them filed. But I usually give it no later than a week. So by next Thursday, if Ms. Ferguson, you haven't signed it, or Ms. Cosper, you haven't signed it, then I would sign it without you. The state would submit it if you haven't contacted them about any changes to it or anything else that why you're not signing it, then I'll get it without your signature and I'll sign it myself. I'll render these orders today. Anything else,
No, Your Honor.
Mr. Asif?
Just a clarification, Your Honor. Oh, I'd like the divorce cause number if someone has that handy, just to write the order.
25-1430- dog, cat, and eagle. Got it? I did that right, Ms. Ferguson?
That is accurate. Yes.
Oh, you meant letters. Dog. Okay. Oh, DC.
Yeah.
Yes.
There.
I couldn't hear when
Right.
she said it, so I was trying to
A
be.
little confused for a second. So 25-1. Sorry, could you repeat that, Your Honor?
You repeat it, Ms. Ferguson.
Absolutely. You did say it correctly, though. So it is 25-1430-D as in Delta, C as in Charlie, E as in Echo.
Okay. Thank you.
Okay, then thank you, folks. I'll be there to court. Good luck to all of you. And all you have to do is
Oh.
click in. Oh, what else?
One more question, Your Honor. Just so I understand you correctly, you'd like me to get Ms. Ferguson and Mr. Cosper's signatures, but not Ms. Cosper's. Is that correct?
No, on our order, because it's gonna have our cause number, you get her signature, Ms. Cosper, just on the one. I'm not having her sign the consolidation because that
Okay.
deals with the divorce and she
Okay.
hasn't made an appearance, hasn't been served, and hasn't answered. So I think that would cover us 2 orders and Ms. Cosper signed just the one. So don't send, well, if you send her the consolidation order, don't put a tab for her signature and don't let her sign
Oh.
it. Don't put her name on it. Don't.
I'll send her a copy of the order as a
Just
courtesy.
send her a copy. Yes, correct. I'm trying to prevent any possible problems, legal problems for her down the road. If that's not fair, she doesn't have a lawyer. Okay, does that cover it?
Thank you, Your Honor.
Thank
you.
you.
May we be
Now,
excused?
everybody's excused. If y'all can hit the end meeting buttons, you're done.